Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hard-working Americans and their families?
You will! This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefits in your benefit plan. Now prepare to learn,
Plan,
save,
and protect with the FIA Group.
Welcome to another edition of Empowering Plans. My name is Brian O'Hara, a senior attorney in the Provider Relations Department here at FIA. With me today is Kelly Dempsey, Vice President of Consulting. How you doing today, Kelly?
Good. How are you?
Good. Very good. Well, here in Massachusetts, at least, the air is starting to get crisp. The trees are bare. It seems like fall is officially upon us. And that, of course, means that football and basketball are in full swing. Kelly is riding high right now after a shutout victory by her Browns over the Cardinals and a statement victory over Steph Curry and the Golden State Warriors on Sunday. Kelly, it's my understanding that you were present for not one, but both of these games.
I was. It was a good day to be a Cleveland fan in general. It was a long day, but it was a good day.
Yes.
It's not very often you get to see a shutout and then to, beat a team when your team looks very different than it did, 6 years ago, to beat a team that obviously there's a lot of hard feelings there against that team. So rivalry games, nice to come out on top. It was a good day.
Excellent. Well, my Patriots look a little different than they did 6 years ago. But I'm not suspecting that I'm going to get any sympathy out there from anyone on podcast land.
Probably not. Especially not me.
No. Well, fall may be a great time for football, basketball, and all these things, but the changing of the seasons, it also means that the new year is right around the corner. And so it's time to start preparing for January plan renewals, believe it or not. Kelly, I'm going to kick it over to you to talk about some of the key requirements to consider. Then I'll delve into the new proposed rules for independent dispute resolution under the No Surprises Act. So, Kelly, without any further ado.
Yeah, absolutely. So, we picked a couple today for the conversation because we could definitely spend hours talking about what the updates are for next year and probably still not go over all of them. So, the easy one that everybody knows that's happening is the ACA out-of-pocket limits obviously went up, as well as the IRS limits for high deductible health plans. The one important thing to note for all of those, that's probably the most notable piece of this, is that the HSA contribution limits for individuals had one of the biggest jumps in history, almost an 8% increase for self-only contributions. So I thought that one was pretty notable because, we see changes every year, and every year it's like, okay, it's a little bit of an adjustment, but this year was a pretty big adjustment. So that's huge, especially for the employers that have high deductible health plans and have their employees on HSAs. I think that's really important to note. I'm not going to go through all the numbers because I don't want you guys to, break your arms trying to scribble and write down all the numbers as I spit them out. But if you have questions, obviously, you know where to find us. We can help with what the different limits are for the upcoming year. One piece that I feel like is kind of overlooked is the COVID-19 tolling requirements. So as we all might recall, COVID has been going on for a long time. There was a national emergency and the public health emergency, which impacted different pieces of the health plan. So while the requirements to cover the testing effectively have kind of gone away, plans can still cover the testing if they want. It's not required anymore. The vaccine is required as part of the preventive care requirements. So that is required for any non-grandfathered health plan. You got to cover the vaccine for COVID. But when it comes to the tolling of the timeline, we're talking about the claims as they're incurred and enrollment rights and the delay that was happening based on that, and that people still have that extended time frame. I think that's a piece that, now that we think, okay, it's over, it's gone, it's behind us, we have potentially overlooked the fact that there is still some tolling that could actually happen through kind of the middle of 2024. So I'm referring to like those COBRA elections and some HIPAA special enrollment elections, as well as just general claims processing. So I have a couple examples that I'm going to go through just kind of very quickly to kind of help illustrate, because I feel like having an example is by far the easiest way to understand when these tolling of times will happen. So the first one is that the plan has a 365-day timely filing limit for medical claims. Pretty standard. 1 year, 365 days. Susie is on the health plan. She's an employee. She had a knee replacement in January of 2023, specifically January 10th of 2023. So the public health emergency for COVID ended May 11th, 2023. and therefore the outbreak period ended July 11th, 2023. So the question is, how long does Susie have to submit that claim? Does she only have the 365 days because COVID's over? The answer is no. She actually has until July 11th of 2024 to file that claim for her knee replacement. If for whatever reason the provider doesn't do it for her, or if the provider does it, they still have that long time. So they have almost 18 months to file that claim. This is because many of those claims that were incurred prior to the end of the outbreak period have that tolling requirement. So it could go until next year. So fact pattern number 2, very similar facts. We'll just say that Timmy had his appendix removed on July 11th of 2023. At the very end, the very last day of the outbreak period, what's the time frame for filing his claim? The answer is he only gets 365 days. He or his provider have until July 11th of 2024 to file that claim. So the timely filing starts the day that his claim was incurred because it was at the end of the outbreak period. So it's something important to remember because, like I said, this still could impact plans through the middle of 2024, depending on the facts and circumstances. You know, the attorney in us, we can't help it. This is always going to be a case-by-case analysis. It's going to be something you're going to look at. But if you have questions or you have a fact pattern that pops up that you're just not quite sure how to handle because the claim was incurred before the end of the outbreak period, reach out to us. We're obviously happy to help. But I just don't want people to overlook that they think, okay, COVID's over. I don't want people to overlook these tolling of timeframes because individuals still have time to submit claims, extra time to submit claims or file appeals or things of that nature. Obviously, the time frame for certain things is going to be shorter than others, but again, it's a case-by-case analysis, and if you need help, let us know. So those are kind of my 2 little bit obvious, but not so obvious updates and things to prepare for next year. But then I'm going to turn over to Brian to talk a little bit about the No Surprises Act, because I've had to look at some of those things recently and they've kind of made my head spin. And now there's a whole new set of proposed rules, and it's just, it seems like every day is something different. So tell us about it.
Well, I mean, it's funny. The No Surprises Act has been full of surprises, I guess you could say. But, we're almost 2 full years into the effective period of the No Surprises Act. And, it's been successful, right, in terms of its intent. It's a patient protection statute. So it's been successful in preventing surprise bills for patients, which is great. However, there have been some hiccups along the way with the dispute resolution process, the open negotiation period, and the IDR process. Some of these problems include an ineffective negotiation process with, parties not meaningfully engaging in open negotiation, providers submitting disputes on items not eligible for open negotiation, all sorts of notice issues. And obviously, there's also a huge backlog of cases right now. As a result, the Departments of Health and Human Services, Department of Labor, Department of Treasury, and the Office of Personnel Management, which we'll just kind of call the departments for the sake of ease, they proposed some new rules regarding this open negotiation and independent dispute resolution process under the No Surprises Act to alleviate some of these issues. One common complaint that you'll hear from providers is that they just don't have enough information necessary to determine eligibility under the NSA and whether or not to accept an initial payment or challenge it. The departments have proposed some changes to improve communications between the parties earlier on in the process. So some of these changes are that payers will be required to provide additional information at the time of initial payment or notice of denial. So this includes legal business name of the plan, legal business name of the plan sponsor, an IDR registration number, which I'll discuss in a moment. They'll need to use specific claim adjustment reason codes known as CARCs and remittance advice remark codes known as RARCs to be specified later on their EOB or EOP. This is in addition to the information that's already required to be disclosed by plans, including the qualified payment amount. The common complaint that you'll see on both sides of the aisle is parties not meaningfully engaging in open negotiations. This can be due to ineligible items being submitted, disputes about missed deadlines, improper notice, et cetera, et cetera. So some of the proposed changes. Currently, providers send open negotiation requests directly to payers using the contact information listed on their EOB. The rule proposes that any payer subject to the NSA register in an IDR registry, at which point they would provide certain information to the registry and they would receive a registration number. And this would be included by the payer on its EOBs and EOPs. Then all open negotiation requests would actually be initiated through the portal. In addition, the rules propose an open negotiation response notice that must be sent to the other party and the departments by the 15th business day of the open negotiation period. This will ensure the parties communicate before IDR, which should increase good faith negotiations. It should decrease ineligible IDR initiations, and it should decrease disputes about NSA filing dates and deadlines.
It's one more username and password to have to remember, right? I feel like there's been so many different registration requirements of this portal and that portal. Like, how do they keep these all straight? It just seems kind of crazy.
I totally agree with you, but having been on the front line of this and dealing with all of these notice issues, I think this will be, even if it's a little difficult to implement at first, I think this will be a positive change. It's going to prevent these issues that we're constantly seeing of, the initiating party just kind of sending an open negotiation notice out into the ether and it never being received and those open negotiations never happening, which is something that happens all the time.
Very true. Okay, I can see
Yes.
that. I guess it's cause for having one more login, one more number.
Of course. Yeah. I mean, what's one more? Just
right.
Just click forgot password every single time you log in like you do anything else.
Touché.
So another common complaint for both parties are restrictions on batching. There are currently certain restrictions on what items and services can be batched together in a single dispute. Now, the rules on batching and bundling are quite confusing and ambiguous, but both parties have complained that they've been forced to initiate multiple disputes on matters that should be adjudicated together. So the proposed change is to allow the following qualified IDR items and services to be batched. So that includes items and services furnished to a single patient on one or more consecutive dates of service and billed on the same claim form. So they call that a single patient encounter. They also include items and services billed under the same service code or a comparable code under a different procedural code system, as well as anesthesiology, radiology, pathology, and laboratory items and services billed under service codes that belong to the same Category 1 CPT code section. The rule also proposes a limit to batch determinations to 25 line items. This could be problematic, and CMS has already received some pushback on this. This limitation could lead to some confusion and delay and inconsistencies in decisions. Anyone who's ever seen, for example, an outpatient ER UB will know that there can be well more than 25 line items on any one of those claim forms, but the claim is adjudicated together. You don't adjudicate each line item individually. The claim is paid as one. So it really should be viewed as one encounter. So that's something they are receiving some pushback on, and I'll be interested to see what they have to say about that.
Yeah, that makes sense to me. And, this is good stuff because I remember when I was trying to dive into the NSA to prepare for a presentation a couple months ago, I had asked you this exact question about help me understand batching versus bundling, because I read it and I think I get it, but then I look at it and I'm like, now I'm confused again.
And I believe that my answer to you was probably preceded by, as long as there are absolutely no follow-up questions. And then I gave you my answer. So whether this makes it more confusing, less confusing, we'll see. But hopefully this will prevent some issues that we're seeing. I currently have a claim in which one provider who performed one surgery with 5 different CPT codes, as is standard, initiated 5 separate disputes. And it really just doesn't make sense to adjudicate a claim on 5 different disputes when these codes should be bundled together. So hopefully it will kind of alleviate that issue. Another common complaint by all parties, including IDREs, is the IDR eligibility determination process. These eligibility determinations can be complex, time-consuming, very resource-intensive. And for IDREs, they're often uncompensated. If after all this work, they determine that a particular dispute is actually not eligible, then technically they don't get paid because there's no dispute to be adjudicated. So the rule proposes that IDR entities must decide eligibility disputes within 5 business days of the IDR selection process, and that parties are going to be required to submit additional information within 5 business days if that information is requested to try to speed this process along. It's also going to establish a departmental eligibility review process if there's a period of what they call systematic delay or other extenuating circumstances. That's not really defined what that is, but if there's a huge backlog, basically the departments will be able to assist with these eligibility determinations. Very quickly, one last thing. There's also been a proposed change to the administrative fee process. Currently, administrative fees are paid to the IDR entities themselves. So the IDR entities collect both the administrative fee that goes to CMS as well as their IDR entity fee. The proposal is to have parties pay them directly to the departments The initiating party would have 2 business days from the date of the IDRE selection, while the non-initiating party, which is 99.9% of the time is going to do the plan, would have 2 business days from the date of receiving notice of eligibility to pay those fees. There's been a lot of pushback on this. As you can imagine, that's a very, very tight turnaround time, especially considering that the penalty for not paying these fees is your offers not considered. So essentially, if a plan doesn't pay these fees within the 2 business day turnaround time, they're defaulted. And that can be a huge deal, if you don't pay whatever it happens to be at the time, the $50 administrative fee or whatever it is, and all of a sudden you get defaulted on a $100,000 claim. It seems like that might be something that they may want to reconsider.
Yeah, and you and I talked about this the other day about just the logistics of how can this get paid in that amount of time, especially with the way that the self-funded industry works. And generally that there's some sort of pass-through of fees between the TPA and the plan. Like, this seems pretty scary from that perspective.
It certainly does seem like this rule was made without much consideration for the self-funded industry and how it works. Just like you said, in the self-funded industry, there's plans and TPAs have, all sorts of vendors and processes that need to be involved, and that takes time. If it's just a fee for you and I for, paying for our gym membership or something like that, it still seems aggressive, but it's doable. But for a third-party administrator or plan, that's a very quick turnaround time. Kelly, it looks like we have a little bit of extra time. Do you want to take a moment to talk about manufacturer coupons?
Yeah, sure. For those that are still listening, if they haven't fallen asleep yet.
Of course they're still listening. This is riveting.
They can get a bonus. So the other looming change that I feel like has the potential to get overlooked for the upcoming plan year, and it really kind of takes effect immediately, so it's not even really the next plan year, but is related to the manufacturer assistance and accumulator programs. So there was a court case. It was HIV and Hepatitis Policy Institute versus HHS, and the district court actually struck down the 2021 Trump administration rule, which allowed the plans and payers to choose whether to apply manufacturer assistance toward deductibles and out-of-pockets. And our understanding from what we've seen is generally it's that those amounts were just not being counted. What we've heard is there's a lot of logistical issues with figuring out what that information is in order to consider it towards the out-of-pocket, and that creates hurdles and challenges. So that was the rule that was allowed. Even if there was no generic alternative available, the plan could set their own determinations related to applying those out-of-pockets and those assistance programs. Basically, what this holding means is that we revert to the rule that was in place before that, if you could remember what that was. It's really just a very conservative approach that you should apply the manufacturer assistance coupons to the participants out of pocket, regardless of whether or not there's a generic available. In this situation, it generally is required. If there is no generic available, it has to happen. There's still a little bit of gray area, but our conservative approach is that you should apply it all the time, even if there's no generic. It's just the way that it should be. And this is based on our interpretation of the original ACA regulations. The wording that they use specifically has some interpretations that it pretty much says that the definition of cost sharing is any amounts paid on behalf of a plan participant. So that can mean by the plan, by a manufacturer assistance program, by somebody else that wants to pay somebody's bill. I know I've had somebody in front of me in line pay for my Taco Bell before, but I've never had anybody in front of me at a pharmacy pay for my copay. I'm still waiting for that day. Maybe it'll happen. I don't know.
I hope you paid it forward at Taco Bell.
I did. Though I will say it happened to be my best friend that was behind me because there were multiples, but she paid for the car behind her. So it was all good. We paid it forward. But that's the big change for the manufacturer assistance coupons and accumulators is that, and I know there's some logistical issues. I can't help but think in my mind when I think through this and, when I go to the pharmacy and I pick something up, if I have a coupon with me, the pharmacy knows what that information is. They know the amount. So they know what that's paying versus what I have to pay. So I feel like it would be some sort of, easy type of data transfer to relay that information back to the plan. From my prior life of working at a TPA, I remember getting the detailed claims reports from the pharmacy benefit managers saying what was what and what's been paid out. It seems like it would just be a little bit more detail. So yeah, there's definitely some legwork, but I'm curious to see what others think about this and how they're going to take it. I know that that's been the challenges that we've heard so far, is that it's impossible to find that information. You never know what the coupon is paying versus what the participant is paying. And sometimes I realize that maybe it's because it's a sliding scale. It might depend what they get from, it's not going to be the same drug every time for every person, because sometimes it's a sliding scale based on income. And obviously individual and household income varies from person to person. But that is the change that happened. That was a court case. Like I said, it was a DC district case that struck down the prior rule that was in place in 2021. So we're going back to 2020, whether we like it or not, to those rules and applying those manufacturer assistance coupons towards the out-of-pocket maximum. Generally, again, our recommendation, conservative approach, is do it for all scenarios. But for now, there's a tiny bit of wiggle room unless you want to take that very strict interpretation of the ACA, which specifically says amounts paid on behalf of the participant, which leads us to believe anything that's paid. So a little bit of a controversial one there, but good information to have, because, there is obviously a likelihood that this could change again. This has been a hot button topic for the last several years, and it's always possible that this could change, unfortunately. So don't shoot the messenger.
The things that keep Kelly Dempsey up at night. You're listening
well, at
to
least
it right
it's not
here.
the Browns and the Cavs this week. So this week I'm gonna ride that high. We had a really good victory Monday this week, and I'm just gonna keep on that for a while.
Well,
especially because I managed to pick up the Browns defense for my fantasy football team. So they got me 23 points with their, amazing display of defense. So
very good timing.
Extra happy.
Well, as you've heard today, it seems like there's a lot to prepare for with land renewal season upon us. Kelly mentioned it many times. You can feel free to ask. With the Browns set for an AFC North showdown with the Ravens this Sunday, you might want to wait until Tuesday to ask your questions if you have any questions for Kelly. But other than that, we are here to answer your questions. I want to thank you, Kelly, for joining me today, and everyone else for joining us on another edition of Empowering Plans.
No, thank you. For the record, I did drop the Browns defense for this weekend because I don't trust them against the Ravens. I love them still, but I don't trust them against them.
Well, thank you for updating the record, Kelly.
But thanks for joining us.